Okay, it is 12 o'clock, so welcome everyone to the Hillwallach Power Hour. I'm your host, John Katz, and we have a great panel for you today, including George Greatrix, Lauren Lightman, Caroline Record, and Ron Pearl. So we're going to start out today with a little quick legal disclaimer. So while we are all attorneys, and in some cases, while we are your attorneys, we are not acting in that capacity today. So what that means is we are going to be giving you some general advice. And obviously, if you have any specific questions regarding your association, you should seek to speak to your either association attorney or your association manager. Next slide, please. A couple other things before we get started. This webinar is being recorded, and we will share the link with you at a later date. If you have questions that you would like to ask during the webinar, please use the Q&A function on the bottom of the screen. We will try to get to your questions during the individual presentations, but if we can't, we will hopefully have some time to take questions at the end. And in addition, we'll be taking some general questions. So if you have something that's not being discussed today, but you just want to throw it out there, we will do our best to answer it. This webinar is approved for 1 hour of CE credit through CAM ICB. However, you must stay on for the whole program to receive that credit. We will email certificates to you within 7 to 10 days after the webinar. And like I mentioned before, we are recording this, so we will provide a link to the webinar to you along with a copy of the PowerPoint slides. Again, probably sometime between 7 to 10 days after the webinar is over. So we have really two topics that we're going to be discussing today. The first one is reopening of pools. And then the second one encompasses a lot of different questions that have come up regarding the Radburn regulations. So Lauren's going to be discussing pools, and we have Ron, Caroline, and George who are going to be discussing all of those individual Radburn regulations. So before we get started, we are going to move to a quick polling question. So our one and only polling question for today is, who are you? Board member, community manager, association professional or vendor, or other? So we're going to give it just a minute or two for everybody to respond, and then we will share the results. All right, just a couple more seconds. Ready? All right, we're going to share the results with everybody. Okay, hopefully everybody can see that. 23% board member, 62% community manager, 2% professional vendor, and then 12%, 7 people are other. So thanks for participating in our survey today. At this point, I'm going to turn the program over to Lauren Lightman, who's going to enlighten us about pools.
Thank you, John. Good afternoon, everyone. And here we are again talking about pools in the age of COVID. But this year, unlike in prior years, at least as of today, we have relatively good news in that in terms of any state requirements, in terms of governor executive orders or health department guidelines, the pools are permitted to operate at full capacity without social distancing, which is good news. And individuals are no longer required to wear masks at the pools, although unvaccinated individuals are strongly encouraged to do so. What I want to point out in this slide in particular is that the facilities are, and they use the word encouraged to develop and implement the COVID operation prevent plan that many of us have had certainly last year, if not also the year before. That identifies the following rules, including a pool director, lifeguards where required, a COVID point of contact, personnel who have COVID awareness training, and even a police notification policy and reporting procedures for noncompliance. Like I said, there's no executive order right now. That does not mean that between now and the end of pool season in September, we won't see anything. We're going to have to be aware as far as numbers go in the state and whether that will prompt any kind of regulations. And also you're going to have to watch what happens at your own facility. If, for example, you have an outbreak in the community, or if you get word that someone or more people were at the pool and a day or two later have symptoms or test positive. So that's why it's a good idea either to develop a plan if you don't have one, or even, utilize and potentially update the plan from last year, because you never know. And it's a good idea to have a plan in action because, it starts, small, and then all of a sudden everyone's talking about it. So it's a good idea, especially the COVID point of contact, to be ready to go with an action plan. And also don't forget that you still need to ensure compliance with the rest of the bathing code, the state bathing code, for the non-COVID provisions, including a trained pool operator and the like. And, in terms of the cleaning and disinfection of surfaces on a regular basis, it doesn't have to be like it was last year, which it seemed like every 30 seconds you had to run and clean. But, certainly common sense here, if particular areas are more highly used than others, that would prompt potential cleaning. And then again, of course, if there's an issue at your facility, that is a whole different ballgame, and you'll have to evaluate that if and when it happens. And, what's also important here is to make sure that you confer with your local health department to confirm any requirements they may have in terms of any COVID issues and COVID cleaning and the like that they are going to require. Next slide, please. So I just want to point out, and these are not verbatim, but just relevant contract provisions. 2 years ago in 2020, when we first had COVID, I think it was March when everything started. And of course, the pools were due to open, and then it was like a panic. What are we going to do with the pools? Are we going to have pool openings? Do we need pool contracts at all? And then it quickly, within the month or two, it came to light that yes, you should maintain the pool for the most part, according in accordance with what your pool operator was recommending. So, and that evolved last year, 2021, whether your pool was opened or closed, you still would have maintenance, potentially guards as well. Going into 2022, I think most of the pools that I'm aware of are opening. Some may still be closed. Some people may still be waiting to see how the summer, comes together with the numbers. So the first bullet point is if the pool isn't open for swimming, reducing the number of days. Also, if you have, again, that outbreak or an issue where you may have to close for a temporary period, that's, that you would potentially get reduced number of days on which the pool will be tested and a refund. And the second bullet point is if you have guards, you could potentially get a credit that you won't have guards, again, if the pool is closed for one of a variety of reasons. So we have that covered. Next slide, please. So COVID, there's not a lot going on, and I knock wood when I say that. And again, that will remain to be monitored as we go through pool season. We could be back here in a month or two talking about the new executive order or the new set of regulations. But I think the more prevalent issue with pools right now, and I set it up here, lifeguards or lack thereof. So when I talk about an anticipated lifeguard shortage, a couple of months ago in February, even January, when the pool companies were reaching out to the associations, I got a couple of panic phone calls that some of the pool contractors were not able to guarantee that there would be guards available for as often as the particular facility would like, whether that meant you had guards full-time or you only had guards part of the time. The question is the availability of guards. So we have that ability there to elect to be considered a specially exempt facility, which is only for the purpose of having lifeguards and first aid personnel present. So the rest of the bathing code, you still have to abide by, but it's defined as a private nonprofit common interest community that restricts the use of its pool to the owners and their guests, or a retirement community that restricts the use of its pool to renters of the units or owners and their invited guests or day use visitors. Next slide, please. So in terms of whether to apply for the special exemption or not, one of the points that came out in my initial discussions with some of my boards was that if you're going to think about requesting the specially exempt facility, which has to be done by request to the local health department, the thought was that if you were going to think about it, do it sooner rather than later, because there were apparently a lot of requests and the health department has to evaluate each one. So the requirements of specially exempt facilities include, I want to point out that the definition applies to the entire facility. And so if there's more than one pool, the whole thing is either exempt or it's not. There's no such thing as having an exemption for part of the one pool and not the other, all or none. Also, the exempt facility must inform the local health authority whether you're going to comply and how you're going to comply, and to complete the aquatics facility plan. So all of that still has to be done. You have to apply as to what your exempt status is going to be, and you still, again, the rest of the plan, the rest of the bathing code still has to be complied with. And again, the specially exempt facilities are exempt from lifeguard requirements, but are not prohibited from providing them if it chooses to do so. So the supervision policy must be outlined in the aquatics facility plan as for the bathing code. Next slide, please. So in terms of the signs, specially exempt facilities are required to post a sign just for the point of the specially exempt facility. Now, I'm not talking about any other signs you may post in your facility. The sign has to be at least 3 feet by 4 feet, stating no lifeguard on duty. Persons under 16 must be accompanied by an adult, and no swimming alone. The sign is supposed to include the hours that the facility is open. And at retirement communities, you also have a sign that has to state the swimming area is closed when the owner or operator is not on the premises, or the pool is closed when the owner or operator is not on the premises. So the swimming area, pool, that language has to be added to signs at retirement communities. So that's your active adult communities. One question that has come up repeatedly is that provision where it says no swimming alone. And I have had the question posed to me by multiple boards. Well, if we have not a guard, but we have, let's say, an attendant who sits there, who's monitoring who's coming in and out, which, by the way, is a good idea to do in case you have a COVID outbreak, then you keep track also of who's coming in and out of your facility. What does no swimming alone actually mean? Can that person sitting there, our attendant, also count as the no swimming alone, so that we don't have to bother our residents with having to bring an adult, person to accompany them to the pool? And the answer, I want to make something clear in terms of the overall special exempt provision. You may have a situation where your health department says, you know what, the plan is fine, plan looks good to us, we're all good to go. You still have to evaluate, though, a potential negligence issue. And I encourage you, I can't, go into every particular configuration here, but you may want to consider, talking to your attorney, talking to your manager, talking to your pool operator and saying, here's what we propose, how does this go? Because if you have a sign that says, like as stated on this slide, and you don't 100% abide by it, you may be in a situation where your exemption is satisfied for regulatory compliance, but you still have a liability issue potentially. So you have to, that's why the sign inclusion of the hours that the facility is open is important, and to abide by it, because you don't want to set up a situation potentially where you have people that are confused about when guards are going to be present, what guards are going to be responsible for, the fact that your attendant, if you're going to designate that person, don't put the association potentially in a situation where you may increase liability where you don't need to. So all these considerations should be talked about within your own community, and certainly with legal counsel and or your insurance representative. And I will leave it there, and John, turn it back to you.
Thank you, Lauren. We did have 2 questions come in. First question was, so if the management office is closed for evenings and weekends, are the pools allowed to be open?
That goes again to having somebody present, though it doesn't necessarily have, you do have to have somebody designated, a designated representative of the association. But again, that is a good question to answer. Certainly with your health department, who is that person? Does it have to be the manager? It could be another representative, but who is it going to be? There should be somebody there who's familiar, both for the exemption purpose and also for the COVID point of contact. I think so. You have to have a couple of different considerations there. Obviously, if the pools are open on the weekend, your manager is not, even if you have an on-site manager and they're not there, somebody should be designated.
And then the other question that we got, and I'll open this up to anybody who wants to respond. Are we still recommending COVID waivers for use of the pool or for other amenities?
I have been helping my clients with waivers. They may be tweaked a little bit from prior years, given the current conditions. But by and large, again, this is where you would want to consult, with legal counsel. But yes, waivers are certainly open, and I'll let the rest of you weigh in. But yes.
This is Ron. I'll weigh in. No pun intended. Weigh in. The waivers, while we call them waivers, actually do a couple of other things. One is they create an obligation. The signer of the waiver form promises not to come to the pool if they're sick or if they've been exposed to COVID. So that's one benefit that's not strictly a waiver. The second major thing, other than waiving claims, is that it assumes the risk. The signer of the document states that they're aware of the dangers of COVID, and they assume the risk in using the facility. So those are two very important things that aren't strictly waivers of claims, but accomplished by that same document.
One more issue regarding the waivers. This is two questions that I'll combine into one. Should we get waivers submitted every year, or can we use waivers from last year?
Like I said, I think you can, some of the waivers, and it depends on what you have in your own community. Some of them may reference prior years' requirements. So you may want to have a new waiver. Certainly though, if you have people who signed a waiver, unless they say, that they're going to be, that they expire, the waivers are generally still good, but you may want to have them tweaked for this coming year. But you don't need to, in my opinion.
Okay, so we're going to switch gears now, and we're going to go from pools to Radburn. I'm going to turn it over to Caroline Record. Caroline.
Hi, good afternoon, everyone. So I'm going to be discussing some perhaps lesser known components of the Radburn regulations that were adopted almost 2 years ago, and maybe just reminding some of you or bringing to your attention what's out there. The first one is new options for the removal of board members. So prior to May of 2020, when the issue of a removal of a board member came up, typically you looked in the bylaws or the master deed or the declaration to see what was in there as far as what had to be done. Many times there was a reference to a petition being submitted by a certain percentage of the unit owners, and then a membership meeting being called, and or the board could bring it up on their own. And then you looked at whether there needed to be a certain number of owners present or of all owners that had to vote in favor of this removal, whether or not a hearing had to be offered, and whether or not the removal had to be for cause or without cause. And that's what we did for years. The Radburn regulations state that a board member may be removed in accordance with the bylaws or by the board for good cause directly impacting the member's ability to serve. So this new option gives the board the ability to propose a removal. However, it has to be for good cause, and the board alone would make that decision. A board member can't be removed simply for disagreeing with a majority of the board. So that would apply to the pain in the neck on the board that exists in some associations who, no matter what is being discussed or said, votes no. The fact that someone is just simply disagrees with everything is not a basis or good cause for removal. However, if there is an alleged violation of a confidentiality agreement, then ADR has to be offered to this board member. And the ADR provider, who in our opinion should be someone outside of the community, has to conclude from substantial credible evidence presented that there was a breach that adversely affected the interests of the association rather than that of the executive board. So what does this mean? It could mean the disclosure of confidential information to someone other than board members. It could mean inappropriate comments or postings perhaps on social media. That is some type of a breach with regard to the interests of the owners. It could be disclosing contract bids received to other vendors who have submitted bids. There are a whole bunch of bases for attempting to remove a board based on this criteria. Keep in mind, though, that as many boards do, if there is a confidentiality agreement in place, ADR has to be offered. But if the reasons for proposed removal are not related to a confidentiality agreement, I think the overriding opinion is that ADR does not necessarily have to be offered. If you are attempting to, a board is attempting to remove a fellow member under this language of Radburn. While I have not had had to go through this officially to remove, I've had discussions with several boards about the possibilities and the evaluation of the facts that were present and what would have to be done. And this may come up again in the future, but I personally have not had to handle this. Another new language in this Radburn regulation is that if a board receives a petition signed by 51% of the association members, that would be starting the removal process as well. So it contradicts what the prior section of the regulation state, which is that you can look at your bylaws as far as a removal process, because this language now created a change to that. And it says that if the board receives a petition signed by 51% of the owners, that starts the removal process. It also says that a special election must be held within 60 days of the receipt of the petition. Well, this has created some confusion based on the language, and as George will mention in a little bit, some of these regulations have been, there's an appeal pending, and I've certainly talked about the appeal since probably a few months after these regulations went into effect, so things may change. But the DCA's position, based on one of its latest documents submitted in reference to the appeal, is that the receipt of the petition alone results in a removal. So there is no need then for this subsequent meeting to vote on the removal. This subsequent meeting is intended to vote for a replacement to fill the vacated spot on the board, unless it's less than 60 days before the annual meeting. So the DCA has allegedly recognized this confusion and has agreed to clarify it in any revised regulations that it presents. The second part of this is open meetings versus the workshop sessions. So for those of us who have been working in this industry for years, I think it was in the 90s, we got the Open Meetings Act under the Condominium Act and Planned Real Estate Development Full Disclosure Act, which said that all binding decisions of the board have to be made at an open meeting, except, and it created 4 categories of topics that could be discussed at a work session or an executive meeting. And if the board made a decision on these areas, that was okay if it was done in the executive session. It was primarily for confidentiality reasons. And just for those of you who may not remember, if a disclosure would result in an unwarranted invasion of privacy, so that was often interpreted to relate to collection issues and or violations. If there was any type of pending or anticipated litigation that the board needed to discuss with counsel, or any other issue in which the attorney-client privilege had to be maintained. If the board was negotiating a contract, that could all be done in the executive session. And if there was any type of an employee-related issue with regard to a promotion, discipline, or termination, that all could be done in a work session, and the decision of the board could be made in the work session. Well, the Radburn regs now state that all binding votes have to be taken at an open meeting. And this contradicts the confidentiality requirements that boards observe with regard to those 4 topics or subject areas. So while you can talk about things in a work session under these Radburn regs, you have to now make your decision at the open meeting about confidential issues that you really can't talk about. So in reading and preparing for today, there was a lot of commentary calling this particular regulation ridiculous. I mean, it just doesn't make sense and it's ridiculous. And I have quite frankly referred to it as dumb because it just doesn't make sense. And so right now, while Radburn, these regulations are pending, and this is certainly under appeal, what a board can do if it makes any binding decisions at its executive session is that it can have a kind of a generic statement at the open session that it is approving whatever it voted on in its executive session, or it's ratifying decisions made in the executive session. Talk to your attorney, whether it's one of us or another firm, about what should be said at the open session. Once again, if you're making decisions in a workshop meeting. Prior to this, it was our opinion, or it is our opinion, that while you could have contract negotiations, the actual awarding of the contract should be done at an open meeting. So that doesn't change a whole lot. I think all of us would fight to the death about any type of discussions with regard to filing a lawsuit or any strategy with regard to a lawsuit. You can perhaps simply reference that you had discussions with your attorney, and that you just have to be careful with not disclosing any type of confidential information in order to satisfy this requirement. The thought is that, and we've all been at meetings where members of the community are alleging that boards are not transparent, they need to be more transparent and whatnot, so that when you make this motion to discuss or ratify what you discussed, you just can't tell them what it's about. So this may, if you've been doing this regularly, raise more questions. And the answer is that we're required to do this under law. One of the issues that, or questions that we received already is about officer positions and whether that needs to be done, and go a little off topic, at an open meeting versus an executive meeting. I think that the discussions amongst the board members as to who is going to serve in what officer position can take place at a work session or an executive meeting, but I always recommend that the actual election of the officers, president, vice president, secretary, treasurer, whatever, occur at an open meeting or the slate is ratified. The last thing I just wanted to bring up are some tips. So we've been doing this election process for 2 years, and these are things that I've seen. Number one, it's critical to, and I ask management to do this, or whomever, is to put the return addresses on the outer envelopes. Without them, we can't verify the envelopes. You believe it or not, a lot of people don't put their return addresses on the mail, so that's a ballot that can't be counted. The good standing notice is required to be sent out if you do have delinquencies in your association. If it's a larger association, 30 days before the meeting. If that notice is not sent out, those people can vote. So it is a requirement. Once again, this is dumb because you've sent them maybe 2 notices already if they're falling behind in the payment of their fees, but this has to be followed. And that's one of the things I always ask: did you send out the notice? The ballots are supposed to be anonymous, but if someone wants to fax or email their ballot to you, as long as they know that they're waiving their anonymity because it's going to be attached to an email or something along those lines that will be separated from the ballot, that is permissible. Write-ins, I don't know how to do this where it doesn't appear to be a signature line. Write-ins are required, and a lot of homeowners feel compelled to sign it. and that could disqualify the ballot. So if somebody comes up with foolproof language, don't sign here, don't write here, and then you see the signature anyway. And then last but not least, verification. When I am handling the ballots, I verify the ballots prior to the commencement of the meeting, which means that I have looked at the return address. I've crossed it to a membership list that this particular person can vote, and I've removed that outside ballot, because while the tallying has to be in public, there's no language in the regulation stating that the verification process has to be in public. And if everyone is seeing that Caroline Record can vote, and then, but so-and-so can't vote, I think that violates confidentiality. So that's all I have. I'll turn it back to John.
Thanks, Caroline. A couple of quick questions that came in regarding removal. So the first question is, once a board member has been removed, can they run again?
I think they can. I think they can. I don't know, unless they're in violation of the standing requirements to be a board member. I think they can throw their hat in the ring next time around.
And that ties into the next question. What happens if a board member becomes delinquent in assessments and is no longer a member in good standing? So that would be a current.
I think under the current regulations, or if there's language in the bylaw, I think that they can be asked to step down from the board, just like an attendance requirement. So I think that they can be asked to step down.
And then one question regarding minutes. So what's the recommendation regarding executive session minutes? We have kept them for many years since there are decisions made legally under the Open Meetings Act.
So Radburn doesn't reference, and someone will correct me if I'm wrong, the requirement to take minutes for closed meetings. So if you can take notes versus minutes, and I know everybody takes minutes for closed meetings. I mean, they're part of the records of the association, so they shouldn't be destroyed. But I think you have to take a look at, for discovery purposes, if there's a lawsuit, minutes should only reflect the decisions, nothing else.
Great. Thank you, Caroline.
You're welcome.
We are getting some other questions, but they have to do some with the voting. And since Ron is going to talk about voting and electronic voting, I'm going to turn that over to him now.
Hello, everybody. Yes, let's talk about Radburn and voting. One of the primary objectives of the Radburn law itself was to clarify owner rights with regard to elections and to prescribe how elections are to be held in community associations. But one of my favorite provisions, because I've been an advocate of electronic notice and voting for a long time, is the provision now that for the first time allows electronic voting. But before we go through it, let's talk about what electronic voting and notice means. I wanted to explain what electronic voting actually is. It is not voting by email. We have a provision that requires confidential ballots, private ballots. And if you vote by email, you know who the vote comes from. So that's a non-starter. But the concept of electronic voting has existed for many, many years in the corporate setting. Large corporations have given shareholders the opportunity to vote online for many years. And in fact, the online voting companies, some of them that have dealt with corporations, are now available to provide electronic voting for associations. But another group of online voting companies has sprung up in response to the rights of community associations to conduct electronic elections. And this authorization, which is statutory now in New Jersey, and many have believed for years that it needed to be authorized by statute before it could be employed, exists throughout this country and in Canada as well, for that matter, where they are doing a lot of electronic voting today. It means internet voting. So these companies have developed websites that allow people to register, to have unique identifications, and to vote online. And we'll talk about the benefits of online voting later on, but it is nothing short of voting via the internet. And so when we talk about electronic voting, we're not talking about emails, we're talking about voting at a secure website. Electronic notice can be by email because for one thing, the same concerns about security and confidentiality don't exist. So if you amend your bylaws to provide for electronic notice, that can be done either by email. Well, it's conducted by email, whether it's done via the association or management or via one of these companies, because all of the voting companies also have a notification requirement, which again is one of the advantages, but we'll talk about that in a minute. I just wanted to summarize the requirements for an association to employ electronic notice and or electronic voting, and we of course recommend that they go hand in hand. The requirements are not the same, and I'll show you the statutory provisions and why that's so. Electronic notice requires a bylaw amendment or consent of the members. It is not necessary that a member specifically consent to receive electronic notices. If you have a member's email address and the bylaw, you enact a bylaw amendment to permit electronic notice, then it doesn't require the specific consent of the member. On the other hand, voting requires board approval. And again, we're talking underlying all of this is a bylaw amendment to allow electronic voting altogether. But once you have that amendment, and I've been encouraging boards, even before the Radburn law, I was telling them to put provisions in their bylaws because I knew that some kind of legal amendment to the law was going to occur someday to allow electronic voting, and it came actually sooner than I thought. But the voting requires board approval and consent by the member. So let's go to the next slide and we'll look at the statutory provisions. So the Radburn Act, for just review purposes, is an amendment to the Planned Real Estate Development Full Disclosure Act, where much of the law relating across the board to the different forms of community associations exists. And by different forms, I'm talking condo, homeowners association, cooperative. So the specific provision we're talking about with regard to notice says an association shall provide association members written notice. And now, in addition to personal delivery or regular mail, they've added or electronic means. And so that's why I say that notice it is now permitted specifically by the statute to be electronic. Next slide. The statute continues, and some of the language in this in the Radburn law, this is out of the Radburn law, not the regulations. And some of it's a little convoluted. So in this case, it says an association shall not prevent voting by electronic means where the executive board, the board of directors or trustees determines to do so, and an association member consents. Now, this last comment on the page, consent can either be separate or part of the voting process. I know some associations have gone around and obtained separate documents that constitute a consent to electronic voting. And that's fine, that's great. But you can also do it by sending out, and it would normally be through the voting company, an email to everybody whose email address you have, inviting them to participate in the process and stating that by clicking on this link and employing the electronic voting process, you're consenting to electronic voting. And that can do it as well. So it could either be a separate process you collect in advance of the election, or you do it during the election process. And the act of voting electronically is considered the consent that you need for a member to vote electronically. And let's go to the next slide. Of course, you can, you must, under the law, provide. Oh, we went too far. I'm sorry, but we'll get to the amendment process in a second. And so the point I was trying to make is that it doesn't have to be a separate process. The most practical way to do it is to engage an electronic voting company. If you don't have all of the members' email addresses, you would do a drive to obtain the email addresses. And for electronic voting to work, the owners, if there are multiple email addresses, like husband and wife, each has his or her own, you have to designate one, because obviously you have to control that there no more than one vote per household. And so they designate an email address. And then with the electronic voting company, you contact everybody, introduce the concept of electronic voting, and say how it's going to occur. And then when the notices of the election are ready, they can be distributed through the electronic voting company with an invitation to vote. It's done in a secure environment. A lot of times there are unique code numbers that are generated by the electronic voting company. They verify that the unique number matches up with the member as shown on the roster of the association, and that's how electronic voting happens. I just wanted to, I thought we had a slide, and we'll probably come to it out of order, but why electronic voting? Why should associations do it? Well, for one thing, you have built-in verification of identity. You have the confidentiality that's now required by law. You have results that are available. That's okay. You have results that are available more quickly. By the way, when I say that the ballots are secret, not even, I've spoken to voting companies, not even the voting company knows how people voted. They only know who voted, okay? And they know when the person voted. So you can find out what the participation level is at any point in an election process, or you can use this for an amendment. This is great for amending the declaration or master deed. And so you can get progress reports. You can customize the voting site to have the name of the association. You can have unlimited, this is one of the things I like, where you can have multiple reminders to vote, and you don't have to pay for it extra. These voting companies have the capacity to send out a reminder, you haven't voted yet, the ballots are due by Tuesday. That kind of thing really gets a high voter participation. And some of the voting companies offer you an annual program where you can have multiple votes during the year on different things. I think net, when you consider printing and postage and all of that, it's a cost savings for associations. And certainly when you pick a voter company, you need to compare prices like you do with any other vendor. So let's go now off of electronic voting. I mean, it's something that all associations ought to do, even if you're not ready to employ it. Get it in the bylaws. And one of the ways you can do that is by the next topic, which is the streamlined amendment process. So let's switch slides here. Okay, the streamlined amendment process, which is really a rejection vote process. Many associations are employing this. This, to me, was a gift that the legislature gave to associations during the Radburn process. It unfortunately applies only to bylaws. It's a method of amending the bylaws, but you can't use it for a master deed or declaration. Why they did it that way, I don't know. I guess because most of Radburn was election process related, and that's usually in the bylaws. Nonetheless, it's as simple as this. The board adopts a proposed amendment at an open meeting. Then the amendment itself plus notice of the passage by the board and a rejection ballot. And it's only a rejection ballot. It's only a ballot that's cast if the person wants to say no. Then you distribute it to the members. They have 30 days within which to send back a rejection ballot. And if fewer than 10% object within that 30 days, the amendment is final. And so for non-controversial amendments, if you have a highly contested issue, it's easy to get to 10%. If it's non-contested, if it's something like electronic voting that nobody really is going to object to, it's really easy. So that's streamlined amendment. And let's go to the next slide. We've often been asked about amendments versus resolution, and I'm running out of time, so I want to give you the short version. Amendments change what's in either the declaration or bylaws. It says black and you want to make it white. That's a change and it requires an amendment. However, you can, by resolution, clarify or provide detail for a document provision as long as it's not inconsistent. So that if you have a bylaw provision or a declaration provision rather that says no commercial vehicles, but there's no definition of what constitutes a commercial vehicle, that can be done by regulation. You can't by regulation then allow commercial vehicles because it would conflict, but you can certainly define what they are. So the most important takeaway from this discussion is an amendment is something that changes the basic governing document, and a resolution is simply the method by which a board of trustees or directors acts. They take action by way of resolution. They can resolve to hire Hill Wallach as their attorney or XYZ as their landscape contractor. Those are resolutions. They can adopt a rule by a resolution. So there's really, when somebody says to me, what's the difference between a resolution and a regulation? Well, a regulation regulates conduct. We know a rule and a regulation are basically the same. The resolution is the memorialization of the action taken by the board to approve a contract, to decide to add plantings to the landscaping during the course of the year. We adopt a regulation governing the use of the swimming pool. Those are all done. The corporation acts through its board by resolution. That's all a resolution is. And the minutes, if you do your minutes properly, they should just be a collection of resolutions adopted by the board. And this statement about hierarchy, the lower documents must always be consistent with the superior documents. The hierarchy starts at the top with a master deed or declaration, then the bylaws, and then the rules and regulations. And the rules have to be consistent with the two above it, and the bylaws have to be consistent with the declaration. Next. I just wanted to mention, and we're going to obviously make this available as well as the recording. You have different types of resolutions, those that deal with internal processes, dealing with an individual situation, or the most common that we deal with are policy. And those are the resolutions that adopt rules, for example. Now, I'm going to end and maybe go over by 1 minute, but I want to talk about emails, which is a non-Radburn issue, but I want to mention it. And the recommendation of our firm, and I hope many others, is that board members should have separate email addresses for their association business. The main reason for that, and I mean, you could either use an association URL or website to get separate addresses, or just get a second Gmail or Yahoo, whatever email service you use, get a separate one for association business. And there are a lot of reasons, including your privacy, where you keep your personal and your business separate. But more importantly, in litigation, emails are discoverable. And experience has shown us and other litigators with whom I've discussed this, that to go through somebody's personal email accounts and to distill all of the relevant emails that deal with the association issue at hand is far more difficult when you have to sift through all the personal stuff than it is if you can just go to the business email. And so you should, if we are your attorneys, contact us for a further explanation about how and why to do this, or check with your own attorney to set up separate, but I strongly recommend separate email accounts for your board business. And that's it. Thank you.
Thank you, Ron. So we're going to turn it over to George now to talk about one of the more confusing aspects of the Radburn regulations. George.
Thanks, John. Hi, everybody. So first, to answer the burning question on all your minds, who's the old guy with the gray beard? Yes, it's me. I lost my razor a couple weeks ago and haven't been to the CVS yet. Anyway, so here we are heading into the spring election season, and one of the issues that you may be dealing with is the new Radburn regulation regarding the affordable housing seat on the board. For those of you who either live or work in a common interest community that has units that are designated as affordable housing units that are administered by New Jersey's Council on Affordable Housing, otherwise known as COA, and if there are less than 50% of your units that are so designated, then you are going to have to abide by the new regulations that came out when the DCA published their Radburn regulations. Interestingly, the Radburn legislation, which is the statute that came out in 2017, said that it was permissible, not mandatory, but permissible for the bylaws of the association to provide for a seat on the board that would be designated as an affordable housing seat. Next slide, please. However, when the DCA published the dreaded Radburn regulations in the summer of 2020, it made it mandatory. So let's read along. It says, when affordable units in accordance with New Jersey's Fair Housing Act represent a minority of units in the development, the bylaws shall reserve a seat or seats on the executive board for election by owners of affordable units. And they do describe affordable units in that statute as either very low income housing, moderate income housing. And if you don't know which units in your development are affordable, you should. And if you don't, you can contact your local municipality because they're charged with administering the program locally. They'll give you a list of what units in your development are listed as affordable. Next slide, please. So when this regulation first came out, there was a lot of debate as to what it meant. And in fact, it may very well be that some of us have changed our mind as to what the interpretation, the reasonable interpretation of that argument is. But first of all, let me just say that it's certainly arguable that the DCA exceeded the authority given to them by the legislation. And in fact, CAI, you're familiar with Community Associations Institute here in New Jersey. We initially, very soon after the publishing of the DCA regulations, decided that many of them did in fact exceed the authority given to them by the legislation. So we filed an appeal. That was in the summer of 2020. Here we are in the spring of 2022, and we are still in the midst of that appeal. The official appeal has in fact been filed with the Appellate Division of the New Jersey Superior Court just a week or 10 days ago. So it's going to be a while before we get any kind of a decision on that appeal. But in the meantime, you should know that if indeed the DCA decided to enforce these regulations, there is a provision for a fine of up to $50,000 for violating it. So we're going to do our best to comply in the meantime until we get some kind of a decision from the Appellate Division. So moving on to the next bullet point, as I mentioned earlier, some have interpreted this regulation to require that an owner of an affordable unit has to be given a seat on the board. In fact, I have an email from Ed Hahnemann, who some of you may know from the DCA. He's no longer there, he's retired, but it was his opinion that it did in fact require that the seat be held by a person who owned an affordable unit. That is not the consensus. It does not require that the candidate they elect be an affordable housing unit owner. What it basically says is that the owners of the affordable units have the right to elect a person to represent them on the board, and that the bylaws require that seat or a seat to be designated as that trustee to represent the affordable unit owners. Can you do that? The answer is it can be done. And I know that you've been utilizing the 2 envelope system ever since Radburn. And that, of course, is what allows us to determine who is voting, but not who that person voted for. It maintains the anonymity that the regulations require. So the way we recommend that you go about doing it is that you separate out the ballots that are sent in the 2 envelopes from the affordable housing owners, right? You separate them out and put them in a stack. And you can do that by looking at the return address that's supposed to be on the outside of the envelope. And then those ballots should be tallied separately from the other ballots. And whichever candidate gets the most votes from the affordable housing unit owners, that person must be one of the trustees seated, even if that candidate doesn't receive more votes than the others. Here's the example on the next page. So let's assume you've got 4 candidates for 3 seats. Candidate A gets 10 votes, candidate B gets 9, candidate C gets 8, and candidate D gets 7. However, candidate D got the most votes from the affordable housing owners. Therefore, candidate D must get that 3rd seat in place of candidate C, even though candidate C got more votes. Think about this. It may very well be that in any given election, you only have one person who is an affordable housing unit owner, is the only one that voted of all of the affordable housing units you have in the entire development. That one vote is going to determine who sits on the board, even with one vote. But bear in mind that even though that candidate D is the person elected by the affordable housing owners, that person's duty is still to the entire community and has no obligation to vote any differently on any particular issue just because he or she was elected by the affordable housing owners. The PRED statute very clearly says that an association shall discharge its powers in a manner that protects and furthers the health, safety, and general welfare of the residents of the community, and that the executive board acts in all instances on behalf of the association. So what that means is that you can't favor one group of your residents over others. Your actions as a board member are supposed to benefit all. So John, I know we're just about out of time. Again, I mentioned that we've appealed the DCA regs. We'll certainly keep you posted. CAI will keep you posted as to whatever the results of that are.
Thank you, George. So we do have another minute or two. I just want to hit a couple questions before we go. So there are older owners who do not have computers or email addresses. Are they allowed to vote in paper?
I'm sorry, the older owners without computers allowed to vote? Yes, you have to make available paper alternative for anybody who either chooses or cannot vote electronically. Does that answer the question?
Yeah, I think it does.
Oh.
So if you conduct a bylaw amendment by the negative vote per Radburn, how soon after being voted down can you do another vote via the affirmative method?
Unless your bylaws contain something that limits you, there is no limitation in Radburn.
Okay, 2 other questions. Does Radburn supersede your bylaws?
In some instances, it does. It depends on the particular provision. But in some instances, it does, and some it doesn't. That it depends on the particular provision you're talking about.
Hey,
I
John,
wanna-
can I ask Ron a quick question? Ron,
Sure.
does the third-party electronic voting company, are they able to handle the issue of the affordable housing units? And how do they know who? Do they have to get that information from the affordable housing unit owner when they cast their vote?
From what I've been told by the companies, they can distinguish classifications. Yes. You still can't tell how those people voted. They would have to segregate the ballots. But that's a good question. And I would suppose it depends on the capacity of the company.
Thanks.
So I want to end on this question because I think a couple people asked it in different forms. So regarding the anonymity, whether you can email a ballot or not, is that something that is written in Radburn, or is that the firm's position?
Well, Radburn says that it has to be anonymous and email address, but at the same time, you still need to verify. So if you can figure out an email process that allows you to have an anonymous ballot and verify it, I guess you can use email, but I can't think of one because emails are you have to identify yourself. And so that's the problem. You have to both identify yourself, but how you voted needs to be kept confidential.
Well, but if the ballot is sent paper, let's say you don't have electronic voting and someone wants to return it via email, as long as they understand that, you know, it's not going to be completely anonymous per the double envelope system, I think that it can be accepted.
Yeah, I took the question differently to mean, can you put a vote in an email? But if you attach, as long as the person is willing to waive their right to anonymity, they can attach a paper ballot to an email. Yes.
Correct. It shouldn't be embedded in the email. It should be attached to the email.
Right. And as George mentioned, hopefully we get some more clarity from DCA regarding these regulations go forward. So we are a couple minutes over. I do want to thank everybody for participating today. I want to thank our presenters, George Greatrix, Lauren Lightman, Caroline Record, and Ron Pearl. As I said in the beginning, if you missed it, we will be making the slides and the recording of this available to you at a later date. We will send that to the email that you registered with. And be sure to calendar the next date for our next Power Hour, which is Tuesday, May 10th at 12 noon. So again, thanks to everybody for attending, and we hope to see you next time.